With that, Attorney General Bob Ferguson.
Thanks, Brianna. Thank you all so much for being here. We really appreciate it. I'm joined by many members of my team. I won't be able to introduce them all today, but I'll be speaking about their work here with this resolution of a very important case. In 2016, my office brought a lawsuit against Johnson & Johnson. It was the first lawsuit brought by a state attorney general against Johnson & Johnson for misrepresenting the risks associated with their transvaginal surgical mesh devices. These risks were serious and sometimes debilitating. They included chronic pain, pain with sexual intercourse, numerous urinary issues, and difficulty of removing these surgical mesh devices once they were implanted. Johnson & Johnson knew about these risks for years, and they misrepresented those risks for more than a decade, even as it sold thousands of these devices here in Washington State alone. After several years now of litigating against Johnson & Johnson, preparing for trial, we've reached a resolution. Trial was literally set to begin this morning here in Superior Court, and we've reached a resolution that holds Johnson & Johnson accountable for its conduct, changes its corporate behavior regarding surgical mesh products, and provides assistance to impacted women. It's a massive undertaking to bring a case like this against an entity as large and powerful as Johnson & Johnson. As you might imagine, they have all the resources money can buy to represent them. That is absolutely their right, of course, but it is a big undertaking to take on an entity of that size in a case as complex as this on behalf of many thousands of Washington State women, and especially to prepare for a trial, which would have lasted some time. And so it's a credit to this team that Johnson & Johnson, literally on the eve of trial, finally came to a point where they were prepared to pay what we thought was an appropriate amount to assist women in our state. So the team here from the Consumer Protection Division, the AG's office, did a fantastic job in going through this case over many years and staying with it to bring to this point where we can announce this resolution. So first I'm going to do is talk about Johnson & Johnson's conduct, then I'll describe the details of the resolution that hold them accountable, and then we'll take your questions. So multiple manufacturers make surgical mesh devices, and Johnson & Johnson is one of the largest. Approximately 14,000 Washington State women had these surgical mesh devices implanted. And while it's difficult to accurately measure, we believe hundreds of those women have been impacted so far. The range of those impacts can be significant, from having to go back for another procedure to literally having one's life altered dramatically. And I'll be reading a letter from one of the women who cannot be here today because this thing settled literally on the eve of trial. She lives in Rochester, Washington, but she sent a letter to my legal team and me, which I'll be reading from shortly, that gives you a sense of the impacts. These mesh devices are implanted into the body and used to treat two conditions in women. Number one, pelvic organ prolapse, when organs shift from their normal positions. That's one way in which these devices are used to treat women. Number two, stress urinary incontinence. So those are the two conditions that women would go and have these devices implanted. These conditions can be treated via multiple surgical and non-surgical methods. Johnson & Johnson knew about the serious risks associated with surgical mesh and failed to include them in the device's marketing materials for patients and the instructions for use packets for doctors. Johnson & Johnson knew about the risks, did not disclose them. The instructions for use are packaged with medical devices and should include any risks or adverse reactions that doctors should know about. That did not happen. Our lawsuit asserted that from 1999 through late 2015, Johnson & Johnson knowingly omitted debilitating complications from these instructions on every device it sold. Johnson & Johnson knew that serious risks were associated with the use of mesh devices, including chronic pain, pain with sexual intercourse, and more, and did not inform patients or doctors. Our investigation revealed that they knew. During a deposition, a member of my legal team asked the global head of medical affairs if he knew about these complications, quote, from day one. He responded that he did. Johnson & Johnson also knew that the impact of these complications would exponentially increase due to the difficulty of removing the mesh once implanted. I recall one woman who spoke about the difficulty of having it removed, and it was the equivalent of having chewing gum removed from your hair. So extraordinarily difficult once you have this device implanted in your body, extraordinarily difficult to have it removed if it's causing problems. Failing to tell doctors and patients about the serious, debilitating, and lifelong risk of these devices had real consequences for Washington State women. It's important, I think, that the voice of those women be heard here today, again, because this thing literally settled on the eve of trial. A number of the women we work with closely, my team mentioned, we were chatting earlier today, that we've been in touch with about 30 to 40 Washington State women about this issue. One of those women, Jean G. Lombardo, is from Rochester, Washington. She said she could not be here today as much as she would like to be. But she sent me a letter. I mentioned her earlier, and her last name, her first name is spelled J-E-A-N. Her last name is spelled G-I-A-L-L-O-M-B-A-R-D-O. And so I'm going to read part of her letter that she sent to me, and she specifically asked that part of her letter be read here today, so her voice could be heard. By the way, she suffered chronic urinary tract infections, constant lower back pain, cramps in the back of her leg. After years of these conditions, she's had it for some time. She's now largely homebound, as you will hear, and suffers from depression and loneliness. She's described her complications as, quote, a nightmare. So here's part of her letter that she wrote. My surgery was performed on October 27th of 2006 in Olympia, Washington. I was unaware there could be any complications from that procedure. It is extremely important for me to have my experience of these past 12 years and 6 months be a part of the public record. It was sometime in late 2009 and early 2010, so a couple years after the procedure, that the problem of not being able to empty my bladder began, as well as having constant UTIs, urinary tract infections. This became a major health concern for me. I was, and she has a paragraph where she talks about how active she's been in the community, living a vibrant life of being involved in the community, traveling, and all things that make life meaningful. Then she goes on to write, that was me then. Now I rarely leave my home. I no longer have a social life, not even within my own family other than my daughter and one granddaughter. I have to do self-cathing 2 to 3 times a day. I have what is called a pessary and see my OBGYN every 6 weeks or so for a pessary cleaning. The supplies needed for doing this daily procedure are many and expensive. The prescriptions for antibiotics have narrowed down to 2 that are effective for the constant UTIs. I am currently taking yet another round of antibiotics for UTI, thus not able to make the trip to Seattle today. Next, I will graduate to having an IV drip to fight such infections. My kidneys have also been impacted. Those co-pays of $50 when I see anyone medically, as well as any other specialist for these past 12 years and 6 months, has left me pretty much unable to financially go anywhere, even if I could or wanted to. I have not spent one night away from my home in many years. I said all of that to say this. I'm no longer involved with others and have no desire to even be part of anything outside of my home. Everything involves medical issues in my everyday life. Today, I need to be heard and validated that I was injured and my life was completely altered and changed due to that surgery in October of 2006. So I greatly appreciate her taking the time to write that letter. My legal team mentioned she's been just such a great, huge help in our case, as have many other women, dozens of women across the state who have reached out to us and helped us as we prepared this lawsuit against Johnson & Johnson. So here are a few of the specifics on the resolution today. Johnson & Johnson will pay the state of Washington $9.9 million. My office will use this money to provide relief to women harmed by Johnson & Johnson's conduct. This relief, by the way, is separate and apart from any relief or recovery that a Washington State woman may receive from a personal injury lawsuit against Johnson & Johnson. There are many of those lawsuits going on right now against Johnson & Johnson, so this is separate and apart from that. A woman can also recover from a separate personal injury lawsuit. We're going to have a claims process for the women impacted. I believe I said at the beginning, we believe about 14,000 of these devices were sold and implanted here in Washington State. We believe hundreds of women have been adversely impacted as a result of these devices. So we'll have a claims process, which you often see from one of our consumer protection actions. So one thing I want to emphasize is that in many of our consumer protection cases, we know exactly who was harmed. We have a list of individuals the business can provide to us of who was harmed. This is a different case. This involves personal and sensitive medical issues. There are HIPAA rules around this. So we are asking and strongly encouraging any one of those women here in Washington State who's had one of these devices implanted to contact our office. We'll then go through a thoughtful process, prepare a claims process to make sure that the $9.9 million goes to women who've been impacted by these surgical mesh devices. A couple more points I want to make. Johnson & Johnson has to make some corporate changes in how they talk about these surgical mesh devices. They are legally prohibited now from making unfair or deceptive statements about surgical mesh, including about the risks. Johnson & Johnson's promotional materials must be truthful, accurate, and presented in a balanced way. If the company learns about new significant risks associated with their mesh devices, it must disclose them. If Johnson & Johnson sponsors a study or research and then cites that study or research in promotional materials, it must disclose its own sponsorship. Our resolution is sending a clear message. You cannot sell medical devices in Washington State and fail to adequately disclose the risks associated with those products. One thing I want to emphasize before we take your questions is that for a consumer protection action, if we go to trial, so trial had started and we had won, we felt we had a very good chance of prevailing in this case, obviously. Any penalties that a judge issues as part of a consumer protection lawsuit in Washington State, by law, the penalties must go to the state, as in the state legislature decides where the money goes. If a case is settled, like this case is, as Attorney General, I can decide where that money goes. And so in this case, this resolution, this settlement of $10 million, allows me to decide that that $10 million will go to the women who have been adversely impacted. Significantly, in a consumer protection action in Washington State, we cannot get restitution for what we think of as pain and suffering. Washington State women can seek that through personal injury litigation. Many have, and across the country as well. And I would encourage any Washington State woman who's had one of these devices implanted, who has not discussed this with an attorney, I encourage them to do that. So this resolution is separate and apart from any litigation brought by a Washington State woman for a personal injury claim, which can include pain and suffering, which we cannot seek restitution for here in Washington State. Bottom line, Johnson & Johnson knew what they were doing. They did it anyway, and they did it for a device that impacts women in as deeply personal way as you can imagine. So I'm really proud of the team to reach this resolution. I'm so thankful, and my team is thankful for the many women who have worked with my team to help bring this case. We needed their voices to successfully bring this litigation to this point where Johnson & Johnson is paying approximately $10 million to the state, so we can turn those dollars back to women to assist with them and the struggles that they have as a result of these products and the deception that Johnson & Johnson engaged in promoting those products. Actually, one last thing I'll mention is that we're the first state to have sued, the first state to have a trial date. California, the state of California has a trial date coming soon. 2 other states have filed litigation against Johnson & Johnson. I'm confident, to put it mildly, that many other state AGs are looking close at this issue as well. These devices are sold throughout the country. So Washington State is not unique. We are simply the first state to file a lawsuit, the first state to get a trial date, the first state to reach a resolution. Washington State is approximately 2.5% of the nation's population. You can do the math on what $10 million is spread out across the country if every Attorney General brings a similar action or reaches a resolution. It would literally be hundreds of millions of dollars, which we believe is an appropriate amount for Johnson & Johnson's conduct nationwide, and we think this amount is an appropriate one here for Washington State. With that, I will stop and take any questions that you have, and my legal team may assist me with answering some of the questions as we go through them as well.
Mr. Ferguson,
Yes.
So if they were prepared to fight up until the 11th hour, what changed for Johnson & Johnson?
So I'll repeat the question. There may be folks on the line, so I'll repeat it. So the question was, hey, if they're prepared to fight as they have for, it's been years. I think we started our investigation in late 2012 and filed the litigation in, help me out, what year was it again? May of 2016. So they have fought it all the way through. I guess a couple of thoughts. One is that it's not especially unusual to have a case settle on the eve of trial. right? A trial tends to focus the mind, and I think it did for Johnson & Johnson, that they're going to have to be in court and defend their actions. So I think that's number one. Number two, and importantly, is that Johnson & Johnson, they knew we were prepared to go to trial. Trial day was coming, and it can sometimes be a challenge for a state office to take on an interest as powerful as Johnson & Johnson and get through all that you get through, all the procedural hoops, all the documents, all the expert witnesses, prepare all that. It's expensive. It's expensive. It takes a lot of people power to do that. And they want to test that to see if you will cave earlier and take a smaller settlement amount to avoid all that investment, time, and resources that is a part of it. So, this goes beyond your question, but as Shannon Smith, my division chief, is here, as she knows when we started, I think there are about, it was a much smaller consumer protection division when I started. There were about 10 attorneys as one example. Now we have close to 30 attorneys. The professional staff has increased dramatically as well. And it gives us the resources to take a case like this to trial. And that's important, that Johnson & Johnson and other powerful interests who want to play by the rules, they know we can take these cases to trial, we're taking them to trial, and we can win. And that tends to focus their mind as well. Other questions?
Sorry, go ahead.
Sorry to be late.
That's right.
I don't know if you or someone on the team would speak to what some of the women have said because of this.
Sure, and I'll ask some of my team who interviewed those women. So I'm not sure when you walked in Essex, I did read a letter from a woman who was impacted by that, which we have a copy of that and can share that with you as well. So she went into great detail about her experience. But I'll open up to if there's someone from the team who maybe wants to speak to a little bit. Go ahead and introduce yourself or step right on up.
Brina Roos. Suffering ranges from one of the witnesses who's prepared to testify at trial had to have multiple surgeries to rid her body of the mesh in order to let go of any of her complications. She had a lot of UTIs, a lot of chronic incontinence that came back. There are women with constant pain, pain in their legs, pain in their pelvic area, painful sexual intercourse that they have throughout their lives, and they can't get all of the mesh out, and so they can't be relieved of those complications.
And I think Essex at our original press conference we had back in 2016, a woman by the name of Donna, if I recall correctly, spoke, and then we had this letter from this woman from Rochester, Washington, who could not be here today. Just given the timing of when this came together and her health issues, frankly, but she's written a lengthy letter, which we're happy to write a copy to you. So I appreciate you asking about sort of the voices of those women because this is so important. If there's a woman in Washington State who has one of these devices implanted, they should contact our office. We do not have their names unless they've already contacted our office. We will have a claims process, but by contacting us with their contact information, once we put a claims process together, we can then reach out to them and let them know what they need to do. So that is extremely important that they do that, and that we are dependent upon them to contact our office. And just one more thing I'll say, Essex, to your question, which is, this team does lots of consumer protection cases, right? And often if someone's been harmed economically, right? There's an economic loss. And that can be a pain too, it can be a pain to deal with an economic loss. Whether it's small or large, that can be an inconvenience. This case is on a different scale, to put it mildly. When you're talking about losing bodily functions, the ability to have pain-free sexual intercourse, to use the bathroom, it's hard to, it doesn't get a whole lot more personal than that, I suspect.
Is there a figure for what the risk factor is? Like, say, 1 in every 10 women will experience a problem or they'll fail?
Yeah, so I've discussed that a bit with my team. So there have been some studies around that. So one thing I want to emphasize is that is still unknown, okay, just to be clear about that. So I don't want to put a specific number on that. But when I asked my team this morning, of the 14,000 devices that were sold here in Washington State, 14,000 devices were implanted in women in Washington State, we believe, based on the studies, but time will also tell as time goes on, but we believe that certainly hundreds of women in Washington State have had adverse impacts as a result of these devices. But I just want to emphasize, we don't know for sure, and some women have had those devices implanted more recently, the health impacts may turn up later on, adverse health impacts may turn up later on. So we just want to be really clear about that. We can't pinpoint, as we often can with the consumer protection litigation, hey, we have this number of consumers impacted in this very specific way. This case is different from that standpoint. We do know the 14,000 number, and the team believes, based on studies that are out there, to your question, that hundreds of women we believe would be impacted adversely at this point.
Does the suit include a requirement that Johnson & Johnson change the way they're made to reduce the risk?
So I'll ask my team if there's anything about the way that they are made, certainly the way that they are promote those materials, right, and discuss the risks. Is there anything else we would add about the way the product is made? Okay, no, so it's the way that they market those materials, and that is what the Consumer Protection Act is designed to do, right? You have to disclose what risks are, right? Here's what the risks are, and you've got to be open and transparent about that, and that did not happen here. I'm not sure if we have folks around on the line. Do you know if anyone's on the line? I'll just open up in case anyone's on the phone line to see if anyone has a question. If not, any final questions here before we, we'll be available afterwards, obviously, at Chat 101. Any final questions here?
Can you give us an idea what kind of profits Johnson & Johnson made selling these 14,000?
So the question goes to, do we have any sense of the profits that Johnson & Johnson made, for example, in selling the 14,000 devices here in Washington State? I'm going to turn to my team to see if we have a sense.
My name is Daniel Allen. Based on discovery that we have received, it's estimated that their profits spanning from beginning of the sale around the early 2000s to present would be in the range of about $15 million.
Is that Washington State specific?
Washington State.
So just to be clear, it's a Washington State specific number that we have. So just to wrap up, again, we encourage women to contact our office. Just provide us their contact information. Would be a huge help for us as we go forward. We also encourage women, if they're not a part of separate personal injury litigation, which many are, most women who've been in touch with us from Washington State, when I asked my team about it, are already in separate litigation, which they're entitled to do, and those kinds of cases can seek pain and suffering, which we cannot. So we encourage any Washington State woman who has not been in touch with a lawyer on that side of the legal equation, we encourage them to think about doing that and having their voices heard through that process as well. Again, yes. Sorry, I go right ahead.
And just to be clear, it sounds as if Johnson & Johnson would still be allowed to sell this implant in this state. Why not stop them from selling it here?
I guess you guys want to speak to what the ability of. So Daniel will speak to that.
Sure. So the Consumer Protection Act doesn't provide us that mechanism. That is something that would have to be controlled by the FDA.
Do you wish you could stop them?
What I would say is I've learned a lot about surgical mesh devices in the last few years, and I'm not a doctor, don't want to give advice in that way, but one additional reason for bringing this litigation ethics, not only to hold Johnson & Johnson accountable, but to have a public conversation about the adverse impacts that many women in the state are experiencing due to these devices, so women in our state can make a more fully informed decision, to be aware of the risks, to hear the voices of other women who have suffered a great deal because of these devices, and that can perhaps help them as they make decisions about their medical decisions going forward as well. So, for me, we have certain tools at our disposal. Other entities have other tools at their disposal. And for the tool that we have under the Consumer Protection Act, we think this is a very positive result, to put it mildly. We look forward to having a claims process for women across the state, and just so deeply appreciate all the women who came forward, helped us with the case, and the legal team that brought this case to this point where Johnson & Johnson was finally ready to write a check for $10 million, and that money will go to this women. Thank you all so much for being here. We really appreciate it.
Thanks, you guys. Yeah, thanks a lot. Big job. Yeah, thanks so much. Yeah, great job, you guys.